I shared the link with him just so it's current.
He might be like me, he might just have taught, so it's always kind of a race back to the office.
Yeah, of course.
Yay.
Great. So welcome everyone. It's 12:02. It's Monday, April 5th, 2021. Welcome to First Mondays. Everyone hear me okay? Thumbs up, thanks. So again, welcome to First Mondays. I'm Ted Barbieri. I'm on the faculty here at Albany Law School. Great to see a number of familiar names and faces on this Zoom link. This First Mondays is an opportunity to, so I'll give a brief intro. We'll pass along to my colleague, Professor Pat Reyhan, to introduce our speaker and our guests today and our theme. First Mondays is an opportunity to delve deeper into a political or business issue through a legal lens. Many of you who have joined before, you know the deal. For new arrivals, welcome, and we're excited to have you here. We've kept up the First Mondays program throughout COVID times, and we're excited to continue to do that today. This academic year, just as a reminder, we've talked about a number of key issues, and we continue to do that today. We've talked about voter suppression in the fall. If you're interested in checking back at our guest speaker then, which an issue that's particularly relevant, we have a podcast. We also have video recordings that are saved on the law school website. We've talked about big pharma, big tech, which is coming back today in the fall. We talked about it in the context of regulation and TikTok. This semester, we had a great conversation with Professor Chung about Wall Street bets. We talked about conservatorship, including in the context of Britney Spears. Today, Professor Reyhan will introduce our topic. In May, we'll have a conversation with another expert around executive powers, so stay tuned to that. Welcome everyone, and I'll turn things over to Professor Reyhan.
Thank you, Professor Barbieri, and let me add my voice in welcoming all of you. And I know there's some of you who will remember this day better than Ted and others will, but it is not that many decades ago that when we went through political campaigns, when we went through any events of national import, that those of us who were interested got our information from only a few sources. We got our information from newspapers, we got our information from radio presentations, and we got our information from television. And television at that time was really just 4 stations, 3 commercial and 1 public station. And at the time, there were actually requirements established by federal law. And this is so interesting to think back on, that in fact, television stations and radio stations there were some requirements that they give relatively equal presentation of both sides of an issue. What a concept, huh, in this day and age. But it was a very, very different world in terms of how we got our information. And as you all know, it's now completely turned on its head. And if anything, newspapers and televisions, at least the 3 traditional television stations, CBS, NBC, and ABC, may be the source for the fewest number of people. So as you know, many times law is late in coming around to what's happening in society. Law very rarely leads. It almost always follows. And so we have this whole new world of platforms and different media outlets that look very different from the old style media outlets. And those new ways of getting information, of hearing information, of acquiring viewpoints have challenged the law. Our guest speaker today has been Professor Rob Heverly. I had the good fortune to teach Rob back when he was 2 and I was 5. And I don't like to disclose how old we are, Rob. And then I've had the fabulous experience of being his colleague. And even in law school, but particularly as a colleague, he's just on the cutting edge of things. He teaches a course in drones. And the only thing you have to get is a drone to be in this class. He looks at issues out there and brings such an interesting, creative look at how the law might respond to some issues that it really hasn't had to respond to in this sort of way. Rob is a graduate of our institution. He's gone on to Yale. He's taught overseas. He's taught here, and we are just so privileged to have him on the faculty. Rob, I'm not going to do a great list of your resume because we'd rather hear from you. So, Rob, I'll let you define the topic because I know it's, as with all of us, it's a work in progress, and turn it over to you.
Great, thanks very much. Sorry for being the one who was a little bit tardy today, but I decided to come to the office because I have to teach at 2 o'clock. And let's just say the technology here kept me busy for about the last 40 minutes or so trying to get myself online. So I'm going to hope that things work. What I'm going to do now is I'm going to share a PowerPoint. And now because I've done that, I've lost all of you. So there we go. That's better now. That I can see. So what I'm going to talk about is law and speech online, which is the topic that people had asked me to speak about. If you see me looking down, it's because I have my multiple monitors with my notes and things. So part of the way to start to think about law and speech online is to think about publishers and non-publishers. And as Professor Reyhan said, there was a world not too long ago where there were physical newspapers that showed up in the morning on your driveway or in your mailbox, and televisions that you watched. And there wasn't much sharing of information among people unless you ran into somebody at the grocery store or saw them at the post office. And there were actual real gatherings of people, something that seems very odd these days, that would give us different sorts of opportunities to learn things. But even if somebody shared something, you couldn't easily verify whether it was true or not. And some of us are even old enough to remember having shelves full of encyclopedias in the home where you would go and look up things that were facts because they were in the encyclopedia. And so that's the way that you could know that things were true or not true. In those times, publishers, people who made statements about things, so I don't mean publishers necessarily as book publishers, but anybody who was speaking, had certain obligations in relation to libel and slander laws. And then part of what we see is those laws seem to have been changed as we shifted online from the 1990s up until today. And so part of what I want to do is I want to bring you up to speed on how and why that change actually happened. Why is it that what we've done is seem to have given greater protection to online publishers than we do to people who are publishing or speaking in what we might refer to as real space or meat space. And I've seen it spelled both M-E-E-T and M-E-A-T because we're the meat apparently. And so I'm going to run you through a little bit of this. And I know it might seem a little esoteric, but it really does give a good understanding of why we are where we are and what might happen next. So as I go through this, I'm just going to run through some of the history that led to the federal legislation that people are either completely enamored with or ready to get rid of. And then we'll look at the effect of that and how it's been implemented. And we'll talk a little bit about some of the proposals and the basis for the proposals, why people are thinking this should be something that should change. So to begin with, we're just going to give you some defamation basics because defamation law provided the sort of ground on which the early battles were fought. And so the Restatement Second of Torts says that a defamatory communication is a communication that tends so to harm the reputation of another as to lower him in the estimation of the community or to deter third persons from associating or dealing with him. So the idea is that when you say something that's false about someone and it causes them to end up in disrepute, you should be liable for that. And it's a well-established sort of principle in tort law that that's the kind of thing that we're talking about. And so as we start to look at how this plays out, who's liable for defamation? Who is it that can be in trouble for defamation and actually have to pay damages? Well, whoever is the original speaker or publisher of the defamatory statement. And you don't need intent to defame here. So if you're thinking back to tort law and all of your intent things, all you need to have is intent to make this statement, and that's sufficient. If it's false and it's defamatory, then you'll be liable for those circumstances. Anybody who republishes the defamatory statement, and by that is, by what I mean by that is they repeat it. If you repeat the defamatory statement, you can too be liable. Again, no intent to defame is necessary. All that's necessary is that you're engaging in the volitional act of speaking, writing, publishing, and of that statement. If you distribute the statement, you'll be liable, but only if you know or have reason to know of its defamatory character. And of course, this is law, so each one of these pieces has a whole variety of things that we can fight about within it that could help us see what it is and flesh this out. But this isn't really about defamation law, but I want us to understand what it is that was going on. Because here with this last one, anyone who distributes the statement, but only if they know or have reason to know if it's defamatory character, that was known as the distributor's rule. That was known as the newsstand rule. Okay, if I'm a reporter and I write something that's defamatory, I would be held liable. My newspaper that publishes it would be held liable. Somebody who says it aloud at a meeting would be liable. But the newsstand owner can't really verify what's in all of the newspapers and what's in all of the magazines. And so that person who's simply taking the speech of someone else and handing it out is not going to be liable unless they know or have reason to know of its defamatory character. So we have a carve out from the people who would be involved in getting statements that are defamatory out that exists in tort law. And this is traditional tort law. That's the rule. So how then does this play out in the internet setting? So I want to take just a quick aside here, because part of what happens when you get into the internet is everybody goes, oh, it's new. Just like I see this a lot with drones. Oh, they're new. We need new laws to deal with this new thing that's shiny and bright. And ooh, look at that. I don't think that's right. I think a lot of people who have thought about the regulation of technology think that that's not right. And taking a page from Jack Balkin at Yale Law School, I think it's more important to look at salience, which is the idea that when a technology comes along, we shouldn't just say, oh, it's new, we need to do something different. We should look at the things that it makes more salient or less salient when compared with prior activities that we've engaged in. So we should ask ourselves, can we in fact apply tort law to the internet without any changes at all? Or is there something about it that's so different, for example, that many people can see what you've posted, even though you're an individual, in a way that couldn't happen before, such that the individual speech now becomes more salient in relation to what in the past had been the power of publishers and broadcasters. So with that kind of thing in mind, we can take a look at where we've gone with defamation on the internet. And so we have some historical developments here. You'll have to excuse me, it's my second screen won't let me see my notes, so I hope I don't forget what I was going to say. There we go. So historical developments. Prior to anything really happening on the internet, we had an initial case that was called Cubby Inc. against CompuServe. And in Cubby Inc. against CompuServe, Cubby was mad at CompuServe. CompuServe was, at the time, the internet for many, many people. The internet actually started as a bunch of what were known as bulletin board services, and you could log in over your computer, you dialed up over a telephone line, and if somebody picked up the phone while you were on, it would cut off your connection. So that meant nobody could call in or call out while you were on the internet, as it was. And so you might pay CompuServe and then you would dial up, but you would not actually be connecting yet to the internet. CompuServe had a bunch of its own services, including discussion boards. And somebody posted something that Cubby didn't like on the discussion boards. And so Cubby said, well, CompuServe is a publisher of that. Look, it didn't exist anywhere before. Now the statement does, and it exists on this platform that CompuServe owns, and they look like a publisher. And the judge in the Southern District of New York said, I don't think so. I don't think they look like a publisher so much. I think instead, what they really look like is a distributor, because they're not looking at the content. They're not doing anything with the content. They're just providing a way for people to get their own content out. And so CompuServe wasn't liable because it didn't know or have reason to know that there was anything potentially defamatory towards Cubby Inc. on its site. And everybody said, okay, that seems right to us. That seems fine. But then Stratton Oakmont Inc. against Prodigy Services comes along. And you'll notice this is a New York Supreme Court case, which actually sometimes in the annals of internet scholarship and internet study causes problems because our trial courts are the Supreme Court and our high court is the Court of Appeals. And I have seen people write about and talk about this case as though it was decided by the state's high court. And you kind of have to sheepishly raise your hand and go, it's New York. We do things a little bit differently in New York. And so this was actually a trial level court. And sometimes that stops people because it's a significant ruling in the development of everything we're going to talk about today, that it was made by a trial court level judge in Nassau County in New York. In Stratton Oakmont against Prodigy, we had a very similar situation. Prodigy was a dial-up service. You dialed up, you could play around in Prodigy's computers and the services they provided. All of these, AOL, Prodigy, CompuServe, eventually began providing access to what we would consider today's internet. But initially it was an insular little box that you would go into, but you could meet other people there and get information there and et cetera. So Prodigy did that, and they had discussion boards as well. And somebody defamed Stratton Oakmont, which was an investment company from Long Island. So Stratton Oakmont said, Prodigy, you're a publisher. And Prodigy said, come on, people, 4 years ago, we decided Cubby Inc. against CompuServe, it was right. And Stratton Oakmont said, that's very nice, but this is a different case because Prodigy, you have people involved in making sure that there's not obscenity, meanness, nastiness. You're editing what's on Prodigy. Distributors don't edit. Newsstands don't edit. You've never picked up a newspaper from a newsstand and they blacked out one of the headlines because they didn't like it. They pass on what's happened. No, Prodigy, you're a publisher. And the court and Stratton Oakmont agreed. And everybody who was on the burgeoning internet, which was really starting to grow and explode at that point, went, if we're going to be liable every time one of our users posts something defamatory, that can't be good. Matter of fact, that would be specifically bad, because we could either take the CompuServe route and say something along the lines of, we're not going to touch it. You folks out there do whatever you want to do. Because if we touch it, we'll be a publisher. But we can't take the Prodigy line that says we're trying to make a family-friendly part of the internet and the services that provide it. Nobody thought that was a really good idea. They wanted the services to be able to cater to different needs and interests of users and people who would be on them. And so we end up with the Communications Decency Act, Section 230 of an act that was passed in 1996. Now, if you look this act up, one of the first things you'll see is a Supreme Court decision which invalidated parts of it. Some parts, not this part. This part has not been invalidated. It's still valid. It's still part of the federal law, okay? And so what we see here is a new section of law that does something very special in the online space. What is it that that section does? Well, there we go. Starts off with findings, with Congress saying the internet and other interactive computer services offer a forum for a true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity. The internet and other, so apparently when I clicked out of impatience, it decided to go way ahead. Apologies for this. Well, maybe we're going to, there we go. The internet and other interactive computer services flourish to the benefit of all Americans with a minimum of government regulation. And then they state policy. We want to promote continued development of the internet and interactive computer services. We want to preserve the vibrant and competitive free market that exists, unfettered by federal or state regulation. We want to encourage the development of technologies that maximize user control over information that's received by families, individuals, schools, etc. So the provision itself provides protection for Good Samaritan blocking of screening of offensive material. And it says, so that's the introductory line. The actual provision says treatment of publisher or speaker. No provider or user of an interactive computer service shall be treated as the publisher, distributor, or speaker of any information provided by another information content provider. Think about that for a second. That does not exist in meat space in terms of a shield from liability. No provider or user of an interactive computer service shall be treated as the publisher, distributor, or speaker of any information provided by another information content provider. And the definition of information content provider is very broad. It's somebody who provided you information. So if they provide that to you and you're an interactive computer service, you can republish it in traditional terms without any danger of liability. They went on. Civil liability. No provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or users considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or, and here's the beauty, otherwise objectionable, whether or not such material is constitutionally protected. Or, so now we have no provider or user of an interactive computer service shall be held liable on account of any action taken to enable or make available to information content providers or others the technical means to restrict access to material described in subparagraph A. So if we think about how this is actually working, right? They start with the first piece. If you republish something and you're an interactive computer service, you're not going to be liable, even if that materials is in fact something that's defamatory to somebody else. And then they say, if you take an action to restrict availability to material, and we really don't even need the obscene, lewd, lascivious, filthy piece, all we need is the otherwise objectionable piece, you won't be liable. No one can sue you for that. And in addition, if you help people to restrict access to information online that they want to restrict access to, you won't be liable. Okay, so we really have here two specific provisions. The second one divided into two pieces, right? We have section 230(1). If you're an information content or interactive content service, you won't be treated as publisher, distributor, or speaker of information provided by another. Under 2A, you're not liable for actions taken to restrict availability of material. And as I think we'll all recognize, otherwise objectionable's pretty much open. We almost don't need to qualify it. And then you're not liable for actions you take to help other people restrict. That changes the game of speech on the internet, right? It changes the way we deal with specifically defamation. And if we think about that little introductory piece, right? The title of the section, Good Samaritan Protection, it was directly aimed at Prodigy, at the Prodigy case, Stratton Oakmont against Prodigy, directly. Congress said, we don't want that to be the rule. Prodigy was doing something good. They were making a family-friendly internet. The internet's kind of wild already. That's okay, we like that, but but maybe some people ought to be able to target things so that they're family friendly and otherwise, and then not be considered a publisher. So we take that then, and we see what the courts did with it in the courts, with the cases that came before them. And we start with Zarin against America Online. This is a 1997 case, as you see, very soon after the passage of Section 230. And Zarin's quite a case. I've met Ken Zarin. He's quite an interesting guy. He has very strong opinions on Section 230, and I'll explain why. In Zarin, Ken was targeted by some anonymous online troll who offered shirts that essentially glorified the Oklahoma bombing. Here's a couple of them here. Visit Oklahoma, it's a blast. There were some other ones, slogans along those lines. And then it gave Ken's telephone number, his home phone number, which was also his business number. And of course, he started getting many angry calls because somebody had said he was selling these kinds of things and making them available. And so he found these postings on AOL and talked to AOL and said, please take these down. I'm being injured by these. And AOL said, oh, yes, we'll help you with that. I think it's coffee time. And they didn't do anything, even though they had told him that they would do something. Following that whole thing where Ken Zarin was essentially hounded for an extended period of time, he sued AOL. And AOL said, what you're essentially doing is you're suing us for the content that somebody else, some other content provider put on our site. You can't do that under Section 230. And Ken said, I'm not bringing a defamation. Well, okay, what's defamation? But no, because you told me you'd take it down. In the court, and Zarin said, no, Section 230 protects this. AOL isn't liable whether they said anything. AOL is absolutely not liable for the content that was posted by this particular user. It was a very expansive reading of the act, and it was one of the earliest decisions in these kinds of cases. Then the next year we get Blumenthal against Drudge. Some of you know Drudge. He does the Drudge Report, still around these days, one of the new kinds of providers that we have in our ecosystem of information and news. And so Drudge was essentially engaged in a contract with AOL. And Drudge had done some reporting around the Sidney Blumenthal stories and had defamed Sidney Blumenthal. And so Blumenthal sued both Drudge and AOL. Now, what had AOL done? They'd contracted with Drudge to carry Drudge's columns, his posts online, on the AOL service. And they had reserved the right to edit those, change them, pick the ones they wanted to post, leave other ones aside, and essentially deal with them as they wanted, but he got paid for that. So AOL is essentially paying him now for content to go on the AOL site. And so Blumenthal says, well, that can't be covered by Section 230 because they're paying for it and they're actually editing it. And the court in Blumenthal against Drudge said, no, Section 230 protects this. Even though they're paying, the information content is being provided by another, they're not liable. That's essentially like saying the New York Times wouldn't be liable when they paid a reporter to write a story and then published it, edited it, and then published it. Very different rules in terms of what we're doing when we're online. We then get Doe against MySpace. And in Doe against MySpace, a young woman, very young, a girl, was exposed to a sexual predator on MySpace, which was a site that was sort of predecessor to Facebook and was a very big deal at the time, and was actually abused. And so the girl's parents brought a lawsuit against MySpace saying, you have an obligation to keep these kinds of people off of your website and to keep them away from young kids. And MySpace said, we have Section 230 immunity here. And the plaintiff said, wait, we're not bringing any sort of claim based on the content. We're telling you, you need to make your space safe. And the court in Doe against MySpace said, no, really what you're trying to do is do an end run around Section 230 by claiming that you're trying to guarantee the safety of a space, when really what you're worried about is the connection that was made between the predator and your daughter. That's content provided online by another. MySpace was held not liable. Now think about the implications of that. We start with defamation. We start with Stratton Oakmont against Prodigy in a defamation case. and Congress say, no, we don't want the online services to be thought of as publishers with this kind of material. So we're going to take the defamation liability away. And suddenly, they're not only not liable for defamation, they're not liable for defamation they pay for, and they're not liable for things that really aren't defamatory at all, because it's content that's provided by another. We have a little wrinkle in this in a case called Fair Housing Council against Roommates. Roommates.com had a website where you could find a roommate. I believe it's still up and running. Roommates had a number of things that you had to answer before you could post on their site looking for a roommate. And some of those, the California Fair Housing Council said, those violate fair housing laws. And roommates, you're liable because you are actually creating the content. You haven't just put up a blank page that says, hey, find a roommate here. You've said, tell us about your sexuality, about your race, about your age. And those are things that you're not allowed to do under the Fair Housing Act. This is an interesting case because we got a decision from a panel on the Ninth Circuit that was then followed by an en banc decision that upheld potential liability for roommates.com. And the court said, because you couldn't post without putting this information in, Roommates was actually a co-curator or co-creator of the information. That means they weren't republishing content provided by another, but they were insisting that the content be included. And again, people went, that doesn't make any sense. It's still content that's being provided by another. The bigger wrinkle here is that in a follow-up case, the Ninth Circuit held that what roommates.com didn't violate the Fair Housing Act, which meant that this decision about Section 230 was irrelevant because there was no liability. It was actually a motion to withdraw or vacate the earlier rulings that the Ninth Circuit denied. So here's this one case that we've got where they're saying, no, you can be liable, but in this very limited circumstance where you say, if you're going to talk here, you have to answer this or say this, and that this was somehow illegal. It's incredibly narrow, right? We sort of emphasize that by using a case called Jones against the Dirty. Jones was a cheerleader. There was a website called The Dirty that encouraged people, like seriously encouraged. Its entire purpose was essentially to have people find pictures and content, post them online, make fun of people, be mean to people. It was what you would think a website that's called The Dirty would do. In addition, the person who ran the website would join in and post comments to things. And so Jones felt she was defamed by some of the content. She sued The Dirty and said, you can't, you're curating this information, you're requesting it, you're helping create it. And the court in Jones against the Dirty said, no, it's information provided by another, and it's exempt from Section 230. And even though the website operator got in there and said things in the comments and was mean, no statement that the website operator himself made was actually defamatory. And so the Dirty and its operator were held not to be liable. Again, the really extreme level to which the courts had gone to enforce this particular law. So this brings us to a few additional cases. Hold on one second. So we have another case from the Ninth Circuit again in 2016 called Doe number 14 against Internet Brands. Internet Brands had to do with Model Mayhem, which is a site that you could go on and list yourself as a model or a photographer and try to find people, make a connection so that you could do some modeling. It's a pretty well-known site. It's done a lot of work for a lot of models and a lot of photographers. Many of them get paid. Others will do what's called time for print. So the photographer takes the photos, the model then has something to put in their portfolio. The Doe number 14 argued that Model Mayhem had failed to warn of a particular person who was preying on the models on the site, although Internet Brands and Model Mayhem knew that that person was there. And it's a case that flows out of very specific law in California about duties in tort law that arise based on the circumstances you're in. And the Ninth Circuit there said, you can be liable because this is not a claim that's based on content of another, but on the actions of the information content provider itself. So the interactive service provider, sorry. And so that was one where, again, we have some liability, but the claim's way outside of the kinds of things that we've been talking about. We get Herrick against Grindr, which was in the Second Circuit in 2019, where Grindr refused to, and people probably know Grindr's a service for meeting people for, to get to know them, I guess is what I would say. They failed to remove fake profiles, which were causing consternation for the plaintiff because people were coming to him and trying to interact with him as though he was those fake profiles. And Herrick brought a bunch of state law claims as well as a variety of federal claims. And the Second Circuit just threw them all out and said Section 230 preempts all of this and is a shield for Grindr in these circumstances. They don't even have to act reasonably. They don't have to act at all. Think about that. Somebody has a false profile online of you, and the legal position is the provider that has that or hosts that has no legal obligation to you to do anything. And one of the more recent cases from just last month in the Northern District of California, Callahan against Ancestry.com, we have another case that kind of looks like it might fall outside of what Congress was worried about when it made Section 230. Ancestry.com buys yearbooks, lots of them. It asks for donations of them, but it buys them as well. So it sources them. It then scans them in and puts the content online, associates it with your name. So one of your yearbook pictures might be out there on Ancestry.com. Someone sued about the inclusion of that information on a variety of causes of action and claims. So they had a bunch of theories that they were, and the court just said, no. I think the yearbooks are information content provided by another, even though Ancestry specifically went out to get them, right? They went searching for them. They pay for them at times. They choose what to put on. They scan it all in. They're neither the publisher, the speaker, nor the distributor for legal purposes. Okay, I don't know what just happened. So I'm going to try. Okay, am I back? Did I go away?
You're still here, Rob.
We're
Okay,
still
well,
here. We can't, there's no slideshow, but we can hear you.
Okay.
Yeah.
Everything on my computer just closed down for a second, including my PowerPoint. So give me 1 second to get that back up because I want you to be able to see the things that people are doing. I see somebody has a hand up. I probably should have said that. I can't see the hands when you have them up because the way I have the screen, that doesn't show. But if somebody wants to, ask a question, that's fine with me.
You've got a hand up
watch
from-
the,
Oh,
watch
sorry.
the
Yeah,
hands?
I have a question just before we go on about how, you know, websites aren't going to be held liable for like for the distribution and the essentially like ownership of, you know, fake accounts. I read an article just yesterday about LexisNexis striking a deal with the ICE where they were going to sell information to them. It was like a multi-million-dollar deal. And that information was going to help ICE along with some analytical tools to, I guess, identify illegal immigrants or immigrants without paperwork and documentation.
Okay.
How legal, like, what does the law say about private information? Because I did read that a lot of private data was a part of that deal. And when, you know, let's say Facebook or LexisNexis or some large internet entity comes in or takes ownership of private information that people give, despite that being private, is it legal for them to then distribute that to people like they're doing with the ICE?
I mean, part of the problem there is that there aren't any real good agreements on what private information is. So it's really hard to sort of make the kind of cases you do. The stuff that LexisNexis has, they'll say that's not private information. They didn't go into your house and get it. It's data that they've taken from public records, from exchanges online, from wherever they can find it. They're not much better than, say, Google when it comes to trying to get just lots and lots of information. They like having information. It's valuable to them. And so they'll say that's not private information. There's nothing private there. Anybody could go and find that information if they had the wherewithal to do it. And so this probably Section 230 doesn't get into that as much, although it could when it comes to the kinds of cases that we were talking about, like Callahan against Ancestry. They wouldn't be considered the publisher of it. If you brought a privacy claim against them, you might be preempted by Section 230. That's entirely possible.
I am reading now that like Lexis aggregated personal data from public and private sources. If they have access to private sources, does that make the data no longer private when they come into ownership of it or they receive a copy of it?
Well, I guess it depends what private they got it from. Like some people would think that a bank is private, but banks sell information all the time. You might think that the grocery store where you use that little card to get 50 cents off, the information they have is private, but that's not private. They sell that all the time. That's how when you show up at a store, you get a coupon that's for the thing that you bought last time so that you buy it again. So really it depends on the information. I think there's very little actual private information that Lexis is likely to have. That would be the kind of thing, I guess, that they would get by bugging your house or doing something along those lines.
Okay, so because someone consented to give, anyone access to that information when they're, scanning their credit card or they're ordering something online, that no longer, like the court's going to look at that as like you consented to that information being accessed.
Yeah, I mean, this is kind of far from where we are when we're talking about these information content providers and their liability for the things that users do on them. We're talking about Lexis is probably core interest. So I want to get back, but just the information and the data questions are really huge. They probably could be their own thing. Europe deals with it very differently than we do. They have the GDPR, which is a rule that gives you as a user a lot more control. California's done that. I think now, I think maybe Maryland has done one as well. Maybe it's Virginia. One of the middle Atlantic states has done one as well. Your information, why does it belong to you? Because it has to do with you. There's all sorts of questions there about the ownership of it. I really doubt that Lexis has really private, like I doubt Lexis has medical information, for example, which the providers of which would be covered by HIPAA and wouldn't be able to release to them. If you've given the information to one person, most likely it would be available to another. So part of what it makes this Section 230 thing interesting is this tension between technology and free speech, right? This is the thing that's really brought it into view today. And I want to try to quickly get through these last little bits because this is the piece that people are interested in. Part of what we saw happen with technology especially through the period of time that involved the election was a lot of people really mad from both sides at the technology providers. So you had people who were saying, don't take my free speech. So that's a free speech, which is an internet thing about free speech, right? Don't take my free speech. And then on the other side, you had people saying, we shouldn't allow bullying. We shouldn't allow false information to spread. We shouldn't allow people to lie. We shouldn't allow people to organize insurrection using your service, Twitter, Facebook, YouTube, Google. And then we saw those entities who were really being attacked by those who wanted to change the way in which the services were used by people to harm others. We saw them take some action. And when they did, people started to push back then and say, hey, you're violating my free speech. Right? You're taking away my ability to speak and to reach other people and to engage with them and to talk with them. But this is the tension from the two sides, right? Both sides were firing at the same time at the same tech providers. And so part of what happens here is we need to look at what the rights are that we're talking about. And one of those is the First Amendment. Congress shall make no law prohibiting, abridging the freedom of speech or of the press, right? That's the big thing. But part of what makes that operative is the requirement of state action. The First Amendment applies to government actions, and all of these entities are private actions. So then you see people start to come out of the woodwork talking about how we can make these private entities into public entities for purposes of guaranteeing free speech. And we see a lot of talk about shopping malls because the Supreme Court has said a state can require a shopping mall to allow the exercise of free speech on the shopping mall property. And we see some others where cable companies were forced to carry television stations, even though maybe they didn't want to. And that was sort of compelled speech. And in each of those cases, a private entity was somehow made to do speech things that the courts and Congress thought were important, even though they were private entities. And so there's a lot of claims about how this is true with YouTube, this is true with Facebook, this is true with Twitter, and they should be treated as state actors and have liability under the First Amendment for censoring, right? Although when we talk about private entities, we generally shouldn't talk about censoring in that way because private entities are allowed to do whatever they want. Now, what are the proposals to deal with Section 230 at this point? I would say the First Amendment thing is up in the air. I'm not particularly convinced that any of the arguments that I've seen are persuasive, but I have no idea how the Supreme Court would go if Congress passed a law trying to apply the First Amendment to the decisions of entities like Twitter, Facebook, and YouTube. I just have no idea where this court would take it. So there are a bunch of proposals to deal with the Section 230 problem. The first one is, of course, just leave it as it is. Everybody's just got themselves all in a tizzy and it'll all just settle down again. Some people want to repeal Section 230 and take away that shield immunity. That would significantly change the internet because the entities would need to do something to try to prevent being considered publishers. One path would be, well, we just won't look at content anymore. Because if we look at content, then we'll be considered a publisher. And we don't want to be a publisher, we want to be a distributor, which is exactly what Section 230 was designed to prevent, right? We wanted them in there doing some of these things. Some of the legislation establishes carve-outs, either based on entity size, like user base or income. Others do it based on the types of content or activity. So depending on what you do, if you're really trying to create some sort of public forum, we're going to treat you as a public forum and apply the First Amendment. Some would require online services to comply with notice and takedown requirement. I was personally involved with a case with an entity that did reviews online. So users could go online and post reviews. And one of the reviews was defamatory, and the business sued the person who posted the defamatory review. And they won the case. It was a default. The person didn't appear, but that's not necessarily relevant. The person who'd been defamed, the entity, the business that had been defamed, took the judgment from the court to this online service company and said, here, this is defamatory. You should take this down now. And they were like, nah, I don't think so. So even with a court order, they weren't required under the law to take it down. And that's what Section 230 does. It doesn't require them to recognize court orders that say take it down. In addition, there are other schemes where you can require removal of material simply with a notice. You file the notice, you do it under oath, you swear that it's true, and then the entity has to take it down. If the person who posted it disagrees, they can put it back up. That would be one model as well. Well, another one would be to make sure that entities are actually complying with the purposes of the law. So this idea of the law saying Good Samaritan immunity and then protecting something like the dirty, which is doing nothing Good Samaritan-y at all. So maybe you should be doing some work that meets the Congress's desires before you get the immunity. We can create exemptions for violations of state criminal law, expand the federal criminal laws to apply to some of what the tech companies do, expand federal civil employment through the Federal Trade Commission, or eliminate my little catch-all at the end of the provision that provided some of the immunity in the law and take away the or otherwise objectionable, so that you get the protection so long as what you're doing is you're actually dealing with obscenity or harassment or those sorts of things. So that's where we really are right now. It's not clear to me what is actually going to happen next. There are a bunch of proposals from a bunch of different people. None seem to really be politically viable at this point. So It'll be interesting to see whether anybody can put together a coalition in Congress to do it. President Biden seems amenable to signing something, but it's not clear what it is that he might sign. So we don't need to leave that up there. So what questions do you have? What other things do you all want to know?
If I may, would somebody who retweets something or reposts something on Facebook as an individual be likely to be held under the distributor rule or the publisher rule?
Well, Section 230 says, right, no user of an interactive computer service will be liable for information content provided by another. So that should mean
blanket immunity, not just for the service, but for the individual.
Well, so when we're thinking about sort of what they do, oh, hold on, my computer's going crazy here. If we think about the language that's there in the actual law, I can't even tell if I'm still online right now.
You're good.
Okay, good. It just my computer just continues to sort of close down everything. So all of my windows and everything closed down. So, I mean, it says protection for good Samaritans, right? No provider or user of an interactive computer service shall be treated as the publisher, distributor, or speaker of any information provided by another information content provider. So you don't need to be the interactive computer service so long as you're using it. So what does that
essentially
mean?
The only way to be held liable would be to be the author of the information.
Yes.
Okay, interesting.
Who might be just anonymous, right? You can post anonymously online. It's really easy. Just make up a name and sign up for a Twitter account and say whatever you want about anybody. Buy a bunch of bots to amplify the message, and there you go. And that's what people are upset about, right? Because the providers have no legal incentive to do anything about that. Market incentives they have, right? Because people are really upset about this happening. And so this is how Twitter kicked a bunch of people off, and Facebook has kicked a bunch of people off. It looks like Elizabeth has her hand up.
Yeah, I was wondering if in the court, when courts are going through litigation like this, let's say for defamation on like a Twitter post or something, like if they're interacting with that, are courts trying to balance a person's right to free speech with the protection that another person is to be afforded? Or where are the courts kind of putting the most weight in a discussion about free speech on the internet?
So if we're in Section 230, they're just applying the statute and they're holding just about everybody not liable in almost every circumstance. Right? We have just a couple of cases of claims that have managed to squeak through 230 when it's involved in interactive computer service. So they're generally not doing too much. They're not talking about free speech. They don't need to. They've got a statute. Why would we approach something that has to do with the Constitution? When it comes to the Constitution and stuff online, well then, yeah, if the government's taking steps. So another part of the Communications Decency Act that was thrown out tried to get rid of indecency on the internet. Imagine what kind of internet that would be with nothing indecent on it. And the court said, no, you can't do that because that's vague and it's overbroad, and all of the sort of First Amendment sort of language that we use when we're looking at government restrictions. When it comes to private entities, the First Amendment just doesn't and hasn't been applied. I'm not saying it could never be. There are some really good arguments that it should apply based on past precedent. I'm not convinced, but I'm not on the Supreme Court, so I guess it doesn't matter whether I'm convinced or not.
Yeah, and I think also ultimately I want to ask what your opinion is with Twitter being considered a private forum, and other social media as well, like Twitter, Instagram, Facebook, things that are really prevalent in the entire kind of global culture. What is your thought on having to maintain that private, like applying law to private organizations like Twitter, despite the fact that it's an incredibly public kind of forum? I mean, it's used by celebrities as a public forum. It's used by a lot of people with little followers as a public forum too. And I think that that's where my biggest question is why are what would have to happen for Twitter to become like a public forum?
Well, I think somebody'd have to make the argument and the Supreme Court would have to accept it. I mean, that's the really practical answer. I think beyond that, a few years ago, Twitter wasn't such a big deal. It might not be in a few more years. We might have something new. What was the thing that happened when Twitter started kicking all of the accounts off that it kicked off? Parler started, right? Well, then Parler had its own problems with Amazon. I think is back at this point, but I'm not positive about that. But you create your own network. There's no reason why you can't do that in a free market, right? Once you start applying the Constitution to private entities, and specifically how you choose which ones to apply it to, creates huge potential problems down the line for new entities, for the existing entities to which it applies, and really expand sort of the reach of government, when really all you need to do is just go start your own. I mean, there's a new one that's called what? MeWe, I think it's called. Maybe it's WeMe. There are other forums that people can go to. Yes, they're not as big as Twitter, but they could become that big. I mean, at the time of the Prodigy decision and the CompuServe decision, those were the big entities. AOL was big for a long time. MySpace was bigger than Facebook. Now it's gone. We don't even know about it anymore, a lot of us. So to the extent that we're trying to leverage sort of like market size to impose constitutional obligations on private entities, I think that changes the market to some degree in terms of those kinds of speech things. Do we have any other questions? Okay, great. Well, thanks for having me here. Thanks for listening to my meanderings about law and online speech in Section 230 and the Constitution. And I'm happy to speak with anybody about this stuff as well. Shoot me an email and we can talk.
Thanks to Professor Heverly for the presentation, for the discussion. Thanks again to Elizabeth Ryan for the inspiration for the topic. We're just getting to the 1 o'clock hour, and I'll just officially bring the program to a close. And thanks everyone for joining First Mondays this month. Thanks to Jeff Sieber for providing support from our Office of Institutional Advancement and Alumni Affairs. Thanks to everyone, and look forward to seeing you again next month.